I'd like to call the Physician Assistant Board back to order. Next item on the agenda, going back to item number 9, update discussion and possible action on certification and recertification of physician assistants by the National Commissions on Certification of PAs. The only reason I put this on the agenda was because a few months ago, there was at the CAPA conference, the national president of AAPA gave a very good presentation talking about primarily the recertification process and the fact that they are considering making I guess, policy statement to no longer recognize recertification as a professional association. Some of the background of that is 22 states currently require recertification to maintain your license, which kind of turns the certifying body into a regulatory body because they can essentially take your license away if you don't maintain your certification. So I just put it on the agenda to bring it up for discussion. It is a national issue. California does not require recertification to practice, as I mentioned earlier in the meeting, and are just opening up to hear what other board members have to say, if anything.
Bob, of course, medicine, we also don't have recertification, but the boards do require recertification for your board credentials. I luckily am grandfathered in since I'm an old guy, but there is the MOCA, as I discussed this morning too. So there is for board certification, but not for licensure. Since the PAs don't really have that board certification problem, it sounds like it's a moot point.
Okay. Well, it's not a moot point in 22 states. They lose their license.
Yeah.
Which is not fair if you're being tested in primary care and you
Right.
do something else.
Yeah, that's the other big issue is that, PAs are trained as generalists, and yet most of PAs practice in specialty areas. So, every 10 years you retake a general medicine exam and you've spent 30 years practicing in a specialty, it's a little difficult.
Very.
So,
Some medical specialists, like hand surgeons, have to take their recert in general orthopedics, and it's quite stressful for them. I remember one of the fellows I work with was talking about it. Well, haven't done that in 25 years.
yeah.
So.
It's an issue all across the spectrum right now for
Yeah,
physicians
and
and PAs.
I just wanted to make the members aware that this is out there looming. Don't know where it's going to go, but certainly the national board, the professional association is looking at it, and I think we should at least be aware of it.
Well, since we follow the medical model, are we moving towards that same area of thought?
I think at some point in time, we may want to, I think first we need to see what AAPA is actually going to come out with. It's my understanding that they're potentially working on legislation in the 22 states that require it for licensure, because that's the first problem
Right.
that needs to be dealt with, because that's just not right to suddenly be 58 years old and told you can't practice anymore. Further comment from the board members?
One last question. Were they thinking about removing the certification altogether, or?
That's what AAPA was thinking, yes,
Okay. Okay, great.
which obviously would have a huge financial impact on NCCPA. They make a lot of money off of recertification. And I mean, yes, now finally they've moved it to 10 years, but it used to be every 6 years.
Right.
So at least they're going in the right direction on that. Any public comment? Okay, we will move on to item number 12, discussion and possible action regarding request for board approval of UCSF Fresno Department of Surgery PA resident program. Mr. Grant.
So the board members and public may recall that earlier this year, we had a postgraduate training program in emergency medicine from the University of California, San Francisco in Fresno at the Community Regional Medical Center. Started an emergency medicine postgraduate program, which we considered, reviewed the materials that they sent us, and approved it because we have a reg that puts us in a position to do that. We are aware that there are other programs like this operating in California that have not been approved by the board. And so at that time, we also voted to try and do a repeal of this portion of our regulations that requires us to approve postgraduate training programs, because we're really not in a good position to make that determination. So at the time that we did that particular program, I'm very familiar with the person running it and how it was going to run, and I felt like we had enough information to make an informed decision about approving that particular program. This request for the surgical program, while they did send a fairly detailed letter and their plan, it is nowhere near as detailed as the request for their emergency medicine program. I would like comments from the board, but my personal feeling is that, one, we shouldn't be in this business of approving postgraduate programs for two reasons. The first, because we're not an educational accrediting body, and the other reason is because all of these people attending these programs are already licensed. So these are people who are doing training that's postgraduate while they already have a license. We're already regulating them via their license. I don't think we need to be in the business of further regulating what they're doing after they have their license, as long as their practice is legal and supervised. Dr. Bishop?
I think again, with the medical model, the state medical board does not approve residency programs for anything. There's boards for that, and I feel a little unfortunate. I think we kind of like the no good deed goes unpunished here. They had some residents who had already signed up and they were concerned, and so we opened that door and it's like, well, let's try again. Yeah. But I do think we are not in that business. It's a bad place to be because it could provide the public with the perception that we're approving these, and we are not.
Exactly. We
have no way to do that. And I think it's if they want to provide a certificate for their graduates, by all means, and that may help them get jobs. But we are not in that business. Absolutely, I agree. For public protection, it's a bad idea.
Right.
I have a question. Is it in one of our regulations? I thought that was the next thing that we were going to do. We were going to approve the one last time because it was in our regulations to do so, and then the next meeting was going to repeal.
Right. So if I understand correctly, correct me if I'm wrong, but those regulations are in the process of being repealed.
So right now, since they have a new program, we have to.
Just not done yet.
Okay, gotcha. No, that's no problem. I understand what
It's
type of work and the
actually item
volume.
number C on the agenda today. All the regulations. Number C is the specialty.
So it's trying to be
Right.
removed, but it's tenaciously clinging on with this one.
Gotcha. I just wanted to make sure I was on the right thing. And then do we have the information from the surgery program?
It should be in your packet.
Okay,
yeah.
gotcha.
And it
Okay.
compared. It's
Okay.
item 12. Compared to the information we got from the emergency medicine program, it's sparse and very general. And is there a member of the public here from this program today? No, I recall for the emergency medicine program, their program director came and
Right.
spoke to us, so.
Jed, do our regulations say may or must accredit these programs? That's the real crux of the matter, because if it
I
says
think it
may,
was
we
an
have
im-
some discretion.
Right.
I think it was an imperative, and that was the reason why we were going to accept what was in practice and then try to work towards rectifying, if I'm not mistaken. And the only reason why, because I was in a residency program, so I think it was a must.
Well, what's the number?
532.
532.
1399.532 is 531. 532 is the one where we have to
531.
go
1399.531.
Yes, sir.
So while they're looking up the exact wording, I would just say that we should not be, I think, just my opinion, that we should not be approving any programs. One, we haven't been there, we haven't verified anything. Two, we don't have enough information. And three, it gives an implicit, or actually explicit, endorsement of the program from the board, and we really don't have enough information to give that kind of endorsement.
Well,
No, really.
no, the board does not have to actually review this. Sorry, I just lost my pen. 3513, we can leave my pen for now, I'll get it later. So basically 3513 says that the board may examine and pass upon the qualification of and may issue, certificates of approval for programs for the education and training of PAs. So that's the statute. And then if you look at the reg regarding specialty training, it just says what the requirements for the program are. It doesn't say the board will do this or the board will do that. So I think it's fine to not review it.
Okay.
So then the next question is, do we need to proceed with the regulations?
Oh, definitely.
Okay.
Do we?
Yeah,
do we-
keep going on that.
Do we need a motion not to review, not to approve, or
I,
just we just won't vote on it? Table it till after the regulatory change, then it won't matter.
I think it's fine to let's see. You can move to not review the program based on all the reasons that you mentioned, and then have the board vote on whether they agree with that. And then if they agree that the board shouldn't review it, shouldn't approve it, but just don't review it, then the board will vote on that, and then you're done.
Okay,
Does that help?
sure.
Okay.
So moved. Sorry.
It's not a motion, but it's a vote.
It's a motion
Well,
not
someone
to-
does need to make the motion in order to have a vote. So Jed did a first motion. Anybody want to second it? That the board should not review it?
I'll second it.
Okay.
Okay, further board discussion?
I just want to make sure, I totally understand. I don't even know if I can ask this question. How long will it most likely, I know you're under duress, I know you.
I'm gonna give you that
Okay.
at my report, if you can wait.
Oh.
It's gonna be at least a year.
Okay,
The process is a long one.
right, okay, I got you, thank you.
I'll explain.
No,
why.
thank you, I believe you, thank you. I just didn't know the time frame. I didn't know if it was a month or 30 days or, okay,
So,
gotcha.
so just being clear, the motion is that we are taking no action on this, right? We are
Yes.
not approving, we're not disapproving, we're just taking no action.
You're just not reviewing. The board has chosen to not review this, based on the fact that you had mentioned that, we're not staffed to do this.
Anticipated
That
regulatory
we don't want to give
change.
that false impression that the board is, verifying the goodness of this program, and however you want to put it, that they're putting their stamp of approval on it. For those reasons, the board is just not going to review it.
Right, and I totally understand that, but I have a question in terms of the program, what they may think since the old laws, and then they want to start their first class in June 27th. By us not taking an action, will that hamper, I know there's no one here, but will that hamper them wanting to, or feeling that they need to start, or can they start, or?
That I'm not sure about. I will check with the attorney for the Bureau for Private Post-Secondary Education, and because that school or the program would actually need to get approved by them in order for them to operate.
Well,
Right.
this is graduate medical education, so I'm not sure if the BPE.
It may not even.
Yeah,
It might not even.
I don't know that falls under the
Okay.
BPE.
Well, yeah, I mean, I don't know of any requirement that requires the board to put its stamp of approval on something before they can go into business as a school or before they can offer the program. Is that what you're asking? Does the
Well,
board
I know that
need
most
to-
residency programs, because the way it's written, they want that stamp of approval from the board, and I think the person who came here, because it does say that, so they may, or people may not want to go to that program based on if it's right or wrong, or in the right, has the right paperwork set apart to do that. So I'm wondering if we don't take an action for the given reasons, will that maybe hamper their program to start, or the people who are coming, or?
It's possible, but if you ask me, that's not really within our purview to, you know,
No,
if
I
it hampers
know.
them, then
I know.
Sorry.
So I guess my question
yeah.
is it better for us as consider saying yes, and then maybe it takes a year to nullify the whole process in general, or would that be, I don't want to hamper the program per se, or the people wanting to attend.
Respectfully, that's not really our job to worry about
Right.
them. And by doing it a second time, now you're setting a real bad precedent. Now we're going to get a wave of these things coming in one after the other from the same place, and it's a bad idea because we are giving a stamp of approval to something that we have no control over. We've not reviewed, we have not analyzed it whatsoever. I think we made a mistake the first time, honestly. We were trying to be too nice to them.
Right, and so I guess my question is, now you have one that is, so quote, approved and one not approved. So I know where we are.
it's not that it's not approved, it's just the board didn't look at it. There's a difference because had the board looked at it and not approved it, that would potentially be an issue for them, but the board didn't even look at it. As far as I can tell, the board's
Okay.
not going to look at it. I just, hang on. Let me gather my thoughts for a minute. Go ahead. Talk amongst yourselves.
Yes.
Yeah,
I
let
have
me
a
think for a
question.
second. Yeah.
You read the statute, then you went to the regulation, and you said the regulation was kind of just
Yes.
silent.
Yes.
And then she raised her hand and said something's gonna take a year. Was that, were
Yes.
you referring to that regulation?
So-
Repeal the regulation.
So the board is in the process of repealing 531 and 532, is that right? I don't remember exactly which numbers. But basically what these regs say, 532 says provides the requirements for an approved program, and then the other one tells you what curriculum it needs to have. But what I was going to say is that, oh my gosh, if the board does choose to review the program, they would need to go through a true review of the program from from a legal perspective in order to protect the board from potential liability in the future. So if the board does choose to review this, it's going to have to be a thorough review. It's going to have to be something that the board wants to stand behind. If that's not possible due to staffing issues or whatever, then I recommend that the board not do it, but not my decision, but those are the options.
Well, I think if you look at the prior program that was brought before us,
Right.
was much more comprehensive in terms of what they're doing.
How they were doing it,
Here to
when,
answer
dates
questions,
times.
and yes,
Right.
very specific.
Very
So a little bit
specific.
easier to say,
Yes.
this looks like it is
And
going to be
approved and
fine.
approved, right.
And they were at kind of a crunch situation.
Right.
This, I don't think gives us enough
Really?
information.
No.
And on top of that all, we're trying to get out of this business, not something we want to do. They're already licensed, the public is already protected, which is kind of where our thing stops. So it would just be redundant to do this.
Another question. We approved one previously based on, there's more detail than this one. So does that open us up to a legal issue if this one is not even discussed? Can they come back and say, you approved one, why are you not approving this one, or even looking at it?
Based on what I've seen of the statute that you guys have, there's no legal requirement for the board to actually do the review. So I get what you're saying, and yes, that's always a possibility, but I think that if the board isn't comfortable feeling that it can do a thorough review of the second one, it's safer to weigh those out and say, well, even if someone says, hey, you did the first one, why won't you even look at the second one? That, I think, is a smaller risk of liability than the second one of potentially reviewing it and not doing as thorough of a job as the board might like to do, and then that's a bigger problem. So, you kind of have to balance it out.
In addition, I'd suggest that if you tell them one of the reasons we're not reviewing it is because we need more information, they're just going to give you more information.
Right.
So you really don't want to open up that can of worms, I think. That's really not the reason we're not reviewing it. We're not reviewing it because we don't have the capability to do it or the staff,
Right.
basically. That's my comment.
And they don't have enough information to. I
wouldn't
go with
the information
Well, I'm just saying, because the other one, we did have substantial information.
And
That's what we
it's not our mission.
Right.
Our regs allow us to, but they don't require it. Our mission is public protection. The public is protected because all of the attendees of this program are already licensed by the board. So we've fulfilled the public protection part of it. We don't have any really requirement to do the rest, from what I can tell.
Further discussion? Public comment?
The motion right now says you're not going to review this one. Perhaps the motion could be you're not reviewing anymore, so that the next time one comes to you, because they don't know that they don't have to. There are 9 postgraduate programs in the state. 1 has been approved. The other 8 started on the job training and never came to you. So if you have this, your motion is no more. When you do get someone calling or sending forms, you can say, we don't do that anymore. So it'll be right at the beginning, and they can continue with their efforts to get 2 or 3 people to come and do their on-the-job training, and there won't be the delay, and they won't be disappointed. It'll just be what it is. That's a suggestion.
I think it does raise an interesting question, though, that you could imagine the school that came to us before saying, we're the only state certified school in California. And not that I think that particular institution is attempting to deceive anybody, but, but one could do that. And so I wonder if we're going to create a policy where we don't do this certification, that we revoke any prior certification without, saying that it's not, that it's without, I don't know what the word is. What's that? Prejudice. Prejudice, thank you. Without prejudice, that so that we're not in that position of allowing somebody to say that.
I would strongly recommend against doing that.
Oh.
As far as I know, and I can double check, but there's no guidelines in place for revoking someone's stamp of approval. I don't know what are we calling it, certification. Yeah. So So there's, and basically when you take something away that you've already given, it's kind of, I'd have to actually do the research to tell you what the standard is. But whenever you're taking something away from somebody, you have a very high bar to prove why you're doing it. Yeah, and I don't know that it would be clear and convincing evidence, but I would need to do the legal research to find out, if that's possible and what that looks like. So, because you could potentially, the board could get sued, and it's just, so I'm happy to look into it and report back to the board, but right now I'm going to say, I would stay away from doing that. And to address your first point of, if that one program says we're the only ones that have the board stamp of approval, there are provisions in the Business Professions Code, like 17,500-ish, that basically say you can't misrepresent the facts to the public, and so there's other ways around it. So if that's actually happening, or if that does happen, not necessarily with this program, but if anybody is showing something in a false light intentionally, then there is recourse.
Got it. Thank you.
But in this case, that would be factual,
Right.
because they would be okay, I just want to make sure.
They would actually have had to do something, and there would have to be an actual claim made that is based on real facts.
So, I forgot what the motion said. Sorry. What did?
No action on this.
So I would move to modify the motion. Can I do that?
Yes.
Just change the motion to say that we'll take no action on this or any other postgraduate programs
Future applications?
or other future applications for approval.
Future requests.
Yeah, future requests for approval, that's correct,
Yeah.
thank you.
You say the board does not issue approvals, right?
Basically, just what I'm trying to say is we're not going to approve any more post-grad programs. We're not doing that.
So the board no longer offers approvals.
I would couch it under for consumer protection purposes, because you're insufficiently, not that you're insufficiently staffed, but the board's not set up to do this.
Because it's not our mission.
Well, it's not that it's not your mission, because if you actually had the staffing and if you were set up to do this, but you're really not set up to do this.
Well, it's a duplicitous need because they're already licensed. We're already doing it.
Right, but I mean, I get what you're
Our
saying.
mission is not to approve educational programs. It's to protect the public in terms of licensees.
True, but
So-
if you were set up to do that, you could be protecting the public by doing a thorough and fantastic review. But because the board isn't confident that they would be able to do that under the circumstances, it wouldn't be in the consumer's best interest to have the board review this. That's kind of where I'm going with it.
Okay.
The medical board actually does approve foreign medical schools, but that's because we have the resources and we do that. That's something we do, not residency programs, but we do certify or approve foreign medical schools that they can be used for licensure here. So, but slightly different thing though, for sure.
Yeah. So the modified motion reads, what did we come up with?
My notes say that the board will take no action on this or future requests for approval.
Okay, need a second.
I thought we had a second.
I'll second that.
Okay. Further discussion?
Just a question about whether we should direct staff to like put this on the website or put it somewhere so that this is like a public policy that people are aware of in case they're attempting to vet their school, wondering like, why doesn't my school have certification? Should we have something on, I don't know where the proper location would be, if it's on the website or elsewhere.
Website.
Can we do that right now, though? Because I think we're working on it, and that might take a year to do. Is that what I'm understanding?
That's regs.
That's
We
regs.
could
regs.
post something on the website. That's the easy part.
Okay.
I have to think about it. The board you can direct the board to work with legal counsel, and if, based on what I find, it's a good idea, then go ahead, do it.
All right,
Okay.
let's do it.
Okay. Further comment? Public comment? All right.
Wait.
But people do call the CAPA office and ask that information. Does my postgraduate program? Until this one a few months ago, nobody was doing it, as we said. So I just think something happened, but I do think posting it is a good idea. And we also share that it's an on-the-job training. There's 2 people in each of these programs. So that's good. All right, thank you.
Okay, there being no further public comment, we'll call the roll. Dr. Alexander?
Aye.
Jennifer Colquist?
Aye.
Sonia Early?
Aye.
Javier Escobar Acosta?
Aye.
Judd Grant?
Aye.
Catherine Hazelton?
Aye.
Xavier Martinez?
Aye.
Robert Sachs, aye. Mary Valencia?
Aye.
Okay, so we're out of the approval business. I would like to skip down to agenda item number 15, presentation by the California Academy of Physician Assistants, Teresa Anderson, and I will ask the board members to go out into the audience, please. Are you doing PowerPoint? Okay. If I'd have waited a minute, the thing would have come down.
Moving, not sleep.
Okay, sorry. Movie and snacks.
No popcorn. I know. I can put them in the back if you want.
Well, I've got it done now. At least I think I have it done.
Good
I think that we're keeping the lights up, so no sleeping. Okay. So, I know everyone here knows me almost, but in the interest of formality, I will. Oh, thank you. Probably so, huh? Okay. I'm Teresa Anderson. I'm the Public Policy Director with California Academy of PAs, and I appreciate the time on your agenda today. We've been getting quite a few calls in the office, so we thought it would be a good idea to give an update to you guys about some of the legislation and regulation changes that are going on in PA practice in different states, and you can see the ones up there, as well as the Veterans Administration. So I'm going to just jump right into Michigan here. So in 2016, Michigan, December 2016, not that long ago, Michigan amended their Public Act. And let me just say, get this a little closer. I'm sorry for all the text on these slides. I usually don't do that. But there's a ton of information. A lot of it was statute. A lot of it was definition. So I really felt that we needed to get a lot of it in here. And don't worry, I'm not going to read word for word all the slides. Some I will. So anyway, the Practice Act in Michigan was amended and did several things, and they're really important things that we should, sort of have bigger implications. The first is it removed the reference to supervision and delegation in their Practice Act and introduced the concepts of participating physician and practice agreement. And the main thing it did, and the important thing that our members have called us about, is that it kind of redefined practice as a PA in their Practice Act. And it defines it as the practice of medicine with a participating physician under a practice agreement. And the law also changed to require PAs to have a DEA number before they can prescribe controlled substances. And wouldn't you think that's a good idea? Become consistent with current law and federal law. So that's just sort of a brief overview of Michigan. We could do this a couple of different ways too, guys. If you have questions during, you can ask me. We can wait till the end, however you like to do it.
Okay, so I have a question.
Okay.
Can you go back to the last slide?
Mm-hmm.
I know they changed the words, but what are the definitions? I mean, they read similar to what we have already, or what was their intention of changing those words?
So moving from supervising physician, where you're tied to your supervising physician's scope of practice, you have a participating physician who is, call it what you want, collaborating,
Right.
whatever you want, but it's a somewhat different type of relationship where you become responsible for your own.
Action.
Yes,
Okay.
yes. Yes.
Does it remove the requirement for review of records that currently exists?
Yes, it does. No co-chart, no signatures.
So what does practicing physician mean? Is it somebody, a coworker, somebody that you work with?
Well,
That is-
a participating physician, you still have to have a relationship with a physician. So whatever that may look like, it's tailored to meet the needs of that practice, meet the
Right.
needs of
Right.
your practice.
Right.
So, and in the Michigan legislation, I would definitely encourage you to look at it too, because it lists out what the practice agreement must have. And it's a signature from both parties. It has a prohibition on acting outside the scope of practice for either party of the agreement. And, back to Dr. Bishop's question about removing co-signature requirements, it really does allow for that practice agreement to reflect the relationship between the participating physician and the PA to sort of customize that, which is, more reflective of how Michigan says their teams practice in the first place.
So basically, they can set up their own agreement. It doesn't have to be the delegation of services. These things must be, and I don't have
Right.
to sign charges.
And there's, I believe, and don't quote me, but I can get it for you. I think there's probably 4 or 5 specific things that have to be in the practice agreement that kind of outline what that looks like. Mhm. So Iowa. This is going to be a little bit lengthier than Michigan. Iowa, in 2015, they passed, there was legislation that mandated the PA board and the Iowa Board of Medicine to work together, jointly adopt rules to establish specific minimum standards or a definition. And the important part here is or. A definition of supervision for appropriate supervision of PA by a physician. And that was to be done by February 1st of 2016. So the committees from both boards came together, developed their proposed language, and put it out, noticed it, public comments. Things were going accordingly. And they both boards received comments back and issued amended regulations to go out for notice. So now we kind of come to the tricky part of what happened in Iowa. The Board of Medicine adopted the amended rules. The PA board received additional comments and felt that there was cause for concern to extend that period, take more comments, and they held additional hearings. And the comments led to them having concerns that the proposed rule that both the boards had adopted, had put out, and the Board of Medicine adopted, would have adverse effects on PA practice. So they did not adopt that initial amended regulation, and still are working on it. I'll get to that in a few minutes. So the PA board issued another proposed rule that really expanded on what they were doing in terms of the existing definition, and like we said, the or was the important part there, the minimum standards. So they held their written comment period, and it ended on December 27th, 2016, and they just held their last hearing on January 6th. I did call the Iowa PA board to see what the outcome was, and I haven't had a call back yet, so I don't really know what the outcome was yet. But I will keep you updated. Now, these are sort of the important part behind all this. When we looked at what the Board of Medicine adopted, their definition of supervision was that the supervising physician retains the ultimate responsibility for patient care. The physician did not have to be physically present and or consulted before each specifically delegated task was performed. That is very important in terms of how they continued their discussion between the two boards. The difference was, now we get to the Oregon, they further adopted the minimum standards. And I would encourage you guys, if you're interested to really look into sort of the details of those minimum standards, to go onto that link there and check it out, and you guys have it. But what they did was include things for the minimum standards that would require face-to-face meetings, assessment of education, training skills and experience, communication, and they were pretty prescriptive about it. And the delegation of services, timely consultation, and alternative supervision, and sort of what happens if there's a failure to supervise. All those were on top of what was already existing. So that's kind of where the conflict came in. Now, the PA board proposed the following rule, and this was the one that was amended, that supervision means an ongoing process by which a supervising physician and the PA jointly ensure that the medical services provided by the PA are appropriate. Going back to what we did 2 years ago, it's very similar. That was the ensuring appropriate, communication. We all worked through that. So there's a big piece of this that is significantly different from what was proposed and adopted by the Board of Medicine versus the PA board. So they're still having conversations to work through that. But what the PA board did not do, and what they maintained and kept in there, was that the supervising physician retains the ultimate responsibility for patient care. They just wanted it to be practice site, flexibility. Again, they did the same thing where the supervising physician did not need to be physically present. The or for the PA board in Iowa was really what kind of was debated and is debated. And like I said, I called, but I didn't get an answer. I haven't heard back from them. This is where they really wanted it to be at the practice level. So supervision must be tailored to the individual practice setting. You guys can see the things that they, how they further defined it. I think the important part is because of the discrepancy between the two boards, the FTC, the Federal Trade Commission, got involved, or was asked to get involved, which leads us to the second part. So any questions so far, or keep moving? Okay. So on December 20th, the Federal Trade Commission submitted a written comment on behalf of the Iowa PA Board because they really did feel that the rule that was proposed by the PA Board would maintain the statutory and regulatory requirements that were already in place, but still allowed enough flexibility, still allowed the flexibility at the practice level and for it to be determined between the supervising physician and the PA. So that was really important, but what they did, they went a little further and they said, in contrast, the PA Board's previously proposed regulations and the one that the Board of Medicine actually adopted appeared to limit such flexibility, and impose potentially new and more costly requirements. They did a cost analysis on that. So the FTC, after analyzing the whole thing, made some recommendations that state legislators, regulators, and policy the decision makers, and I believe this is also sort of their broad perspective, and I would say across every state. So they believe that that the policymakers need to evaluate if any pertinent evidence exists to maintain or add the scope of practice restrictions. And I think nobody was saying that this was necessarily a scope of practice issue, but that it was really about how you practice at the practice level, what it looks like in your everyday practice. So. They also believe that it should any of these issues should be evaluated to make sure that if the health and safety concerns are put out there, that they're well founded, that there's real justification for those, and to consider what if other less restrictive alternatives would be available that would also have the same consumer protections without undue burdens or limits. So their conclusion throughout all this, and believe me, this was quite a process, was that they support the PA Board. They supported the effort and believe that it complied with the legislative mandate. They also believe that the definition of physician supervision was upheld, and it did not create additional burdens that the previously noticed one did. So it was sort of a big deal that the FTC came in the side of the PA Board and really offered their support so strongly. So that takes us through Iowa. If there's any...
Can I ask you a question about Iowa?
Sure.
Who put forth the change? So was it the board or was it...
So it started with a 2015 legislation that passed, and because of that legislative mandate, the two boards were mandated to come together and work on those together. And really, it was the intent was to update the Practice Act, and I mean I think we all have talked about that, what that looks like in terms of day-to-day practice. So, any more questions on Iowa? Okay. Now we get to the Veterans Administration. Probably, I don't know, do you guys know what happened with the Veterans Administration? Anybody? So they granted full practice authority to advanced practice registered nurses. They changed the regulations, and it was proposed on May 25th. It is final now. They proposed that it started out with 4, different roles, the APRN roles, and I'll get into that a little bit more. But basically, it was they wanted to change that Title 38 in federal regulations to permit practice authority, full practice authority, sorry, so that they, as long as the APRNs were acting within the scope of employment within the VA. So this is just specific to the VA. They put it out there, and after initial comments, they moved to proceed with 3 of the 4 roles. CRNAs were not included. And just not too long ago, a month ago, just over a month ago, the final rule was published, and it became effective 10 days ago. The final rulemaking established the professional qualifications that are required for APRNs to have full practice authority within the VA, and criteria under which the VA may grant full practice authority. So they really did go through each one of them, the certified nurse practitioners, clinical nurse specialists, and certified nurse midwives, and talk about scope of practice and sort of define scope of practice, if you will, for the 3 roles. Regulatory change, and the reason I have so much text on here, guys, really is because of their definitions and that it's within their new regs in the VA. So the regulatory change to the VA nursing policy permitted the 3 roles to practice to the full extent of their education, training, and certification without, here's the important part, without the clinical supervision or mandatory collaboration of physicians. The final rule also uses full practice authority to mean refers to the APRN authority to provide advanced nursing services without the clinical oversight of a physician. Again, they specified that it was when working within the VA, as an employee of the VA. The final rule was very clear that it preempts state and local laws for VA employees that are practicing within the scope of their employment. The reason, and I think I probably have those here. Oh, look at that, I do. The reasons that they, oh, wait, I'm ahead of myself a little bit. The reasons that they stated that was to standardize practice for those other 3 roles. It had more to do with all the sort of conflicts within different states. So you might be able to do this in that state and this in that state, but not in that state. So they just wanted to standardize it across the board and have the federal law preempt state and local laws. However, there is an exception on controlled substances. That's all federal. So there was no wiggle room and no need for it because it was already standardized. So now I'm kind of caught up in my head here. So reason stated for not including the certified registered nurse anesthetist was, that actually caused quite a bit of stir. There was a lot of talk about that. But they felt that including CRNAs in full practice authority would eliminate the concept of team-based care in anesthesia services. I think we all have team-based care is kind of what we do. So the VA does not experience, and the other reason they gave was that the VA, they believe they do not experience a current shortage of anesthesiologists within their system. So those were the reasons stated for not including CRNAs.
So this VA is across the board in the United States, California, to
Yep,
New York,
it's federal,
okay.
yeah. So you can, if you work for the VA, you can sort of go in and out of any state and have this be your scope if you're one of those roles. Now, comments were submitted requesting PAs be granted full practice authority within the VA, and the VA responded to that request that it was not addressed in the proposed rule, so granting such authority in the final rule was way beyond the scope of the proposed rule. So they did not, that was not something that they were willing to consider in that. Any consideration of granting PAs that full practice authority would have to be done in future rulemaking, and the VA did acknowledge that and say that that is something, I don't know where that lies, but that something that they recognize. Yes?
What's the definition of advanced nursing services?
That I would encourage looking at the VA regs because they didn't. I didn't find where that was actually defined in the proposed rule. It may be in a VA policy where they outline exactly what those are.
Okay, thank you.
Any other questions? That takes me to the end of the text in this, but open to questions if anyone. Okay.
So with all that information, and maybe Gay can help out as well, CAPA being California, do you guys have something that we are moving towards for California VAs, or with all the new regulations happening, how do we have a stance, or?
So I really appreciate that question because we are getting a lot of calls from our members saying, and part of bringing this to you guys as a board is I kind of expect that you're going to get some calls pretty soon too with other PAs moving from other states coming in here. Maybe PAs working for the VA might call and say, hey, what's going on? I do see a lot more conversation happening. I know that for us, we're getting a lot more calls. So our board meeting is actually this weekend, and this is top priority on our agenda because there's a lot of conversation about from our members, and really it comes down to, you know, our principles are in team-based care. So we're not, this isn't about not talking about team-based care, but it's also talking about losing market share. Our members are calling quite frequently saying, look, this system is telling me that they're only going to hire NPs because you guys are just too hard to work with. We have the administrative barriers, we're fully liable, docs are not liable for the, and I say APRNs based on the VA, but nurse practitioner, you know, they're not, they don't hold that liability. So it is becoming a bigger issue.
Could we return there so we can record all the questions and answers? Would that be okay?
Did
Bob?
you?
Could we return to our seats so we could record the question and answers for the
okay.
video?
I get what you're saying. Do you want me to stay here and answer questions?
Yes, please. Thank you.
Motion.
It is.
Oh, it is. Oh, I see. The questions are.
Number one. So I wanted to ask if your members had, in their comments with you, this specifically addresses the VA and what's happening, and a little bit about Michigan and Iowa, but have they specifically complained that they feel that they are losing jobs or market share to our nurse practitioner colleagues in California because of how the PA Practice Act is worded and the requirements for documentation, things like that?
So we hear frequently, quite frequently from our members that yes, they are losing jobs. They're concerned about their employment opportunities and market share because of the challenges that are expressed by larger systems and even group practices about the requirements of working with PAs. The paperwork, the liability, what I was saying earlier. To me, I haven't actually, they haven't said, you know, section 1399 point blah, 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 or being PICO blah, blah, blah hinders me. But what they're telling me is it's challenging to work with. You know, they're being told that they're too challenging to work with. In fact, one of our members even surveyed some of the larger systems, and they said, no, we actually prefer NPs because of that, because of the co-signatures, because of, you know, all the things that we've talked about. So, yes.
So if I understand correctly, then it could be interpreted that our Practice Act is sort of a barrier to employment for PAs in some cases.
I
Is
think
that
some
correct?
parts of it certainly are, yeah, for sure.
Are you planning on trying to get some legislation started?
At this time, we don't have, for this legislative year, our agenda is not around those issues, per se. And I say that kind of, with caution. What we do know is, and let me back up a little bit. Our board has not really talked about this. These are very recent. December, we haven't had a board meeting since some of these came out with the VA and with Iowa and the FTC. And I think I might be a little bit ahead of myself with Michigan, but I don't think we haven't talked about Michigan at the board. So these are all relatively new, but we've been consistently getting calls from our members for quite some time on the issues of challenges working with PAs, administrative barriers, I should say, not challenges. So one of the things that we looked at sort of as a broad agenda item for legislation is where are the barriers? Well, we know there's many, many different forms that physicians, that say physician only, that only a MD or DO can sign. Some of them allow for NPs to sign, but there's many that PAs can't sign. So we're looking at what forms. Is it in Medi-Cal? There's certain things that as California we can't do, Medicare, home health, hospice, that kind of stuff. That's federal, so that's sort of off the table. But Medi-Cal forms, school forms, stuff like that. We're definitely digging in and looking at what we can't sign.
Well, you've expressed that there's barriers to getting jobs for PAs. Is this resulting in any barriers to access to care by Californians? Because that's really the critical feature here.
Right.
If we start eliminating PAs from the workforce, is this going to inhibit access to care for our California citizens? I think that's the crucial thing that we want to know and going forward, because we keep hearing there's a problem with access to care, especially in rural areas, and physician extenders are the answer. So I'm just wondering if it seems to me that's the critical information that's needed as we go forward as a board and as a state.
And I would say anecdotally, yes, we've heard from some of our members that positions that say NP and PA, they'll hold them open. Even when a PA has applied, they'll hold them open waiting for an NP. So I would say, yes, it is compromised. I don't know to what degree, but definitely I think it's a problem.
If I could just, if I could just add on, I think this could be an issue with the North Carolina FTC thing as well, because if it's our regulations that are preventing PAs from getting jobs, then we're creating a barrier for those PAs, just like the dental board did. So I think it would really be incumbent on us to look at precisely what part of our regulations, which it sounds like is some of the supervisory requirements, documentation or something, that are actually the elements of our PA Practice Act that are making a barrier.
So the FTC part of it, I would defer to legal minds. Go ahead.
I would need to review your the Practice Act to see what it says, but basically, if it's something that's in statute, the only people who can change that are the legislature. But if the administrative barriers, as we're calling them, are in the regulations, then yes, the board can definitely look at those.
And I could tell you what we hear time and time again. It's the co-signatures, for one. That's a big, let your practice site determine what's appropriate supervision or documentation, I'd say, what's appropriate in your site. What we hear time and time again is the physicians say that they rather work with their nurse practitioner because they're not ultimately responsible for their actions. So I think, those are the things that we hear consistently. And of course, Gay, she answers the phone time and time again. So I know you'll have a lot more to add to some of the specifics, but those are the ones we hear pretty consistently.
Well, from our legal analyst, as I understand it, that the state can indemnify itself against anti-trade. The legislation can do that, but the boards cannot. So this sounds like it might be something that needs to go to get our DCA colleagues involved too, to see what we can and should do, see if we are at risk as a board if our regulations are considered to be anti-competitive in any way. So I think that's another place we need to look at this. It seems like we potentially open ourselves up for any problems that way. Our regulations are anti-competitive.
Well, it would be the antitrust issue comes in where the board is trying to, and I'm not saying the board is doing this, I'm just trying to flesh out what this means. When you have an antitrust issue, it's when the board at issue is trying to keep other people out of their field.
Mm-hmm.
So that's not entirely what's going on here. It's more like other people. Yeah, we're keeping our own people out, I suppose. Yeah, that's a good way to put it. But yeah,
true.
so you would look at it with a different set of eyes. But basically, I just wanted to clarify the North Carolina issue. It's the board saying, no, you can't do what we do because we say so. And when it's in statute, it's much easier because the legislature has decided, not the board.
And in the Iowa situation, the reason the FTC came into that was because they did believe that the supervising physician had control over how the PA enters the workforce, and there might be some overlap in primary care services delivered. So they did see some cause for concern there, and that's why they looked at some of those issues.
I just want to share my own experience. So last year I passed through, probably I went for over 12 job interviews, and probably 70% of those clinics, companies, and hospitals, they were telling me that they prefer NPs more than PAs just because the MDs, they prefer not to oversee the 5% of review all those charts. And so I find out a little bit more challenging especially for a lot of the PAs. My position I was applying to was more linked to administrative roles. So, but I noticed that it was a big challenge, or it's going to be a big challenge for different other PAs. At the same time, it was like even 2 hospitals. I even request information to Glenn, Mitchell, and also to Lena last year because they didn't even have any rules or regulation about how to supervise PAs on those, especially in one hospital, and because they only hire NPs because they don't want to oversee the 5% of the charts. So if I had that experience, I can imagine how other PAs are passing through many of these things.
And to the administrative piece of that, we hear from our members frequently different roles that they can't get. One of them in particular is the Family Pact program, permits MD, DO, or NP to do the orientation and be that role for the Family Pact program, but not PAs. And we called to inquire about that, and we're still trying to figure out why.
I have another personal account. I spoke with a fellow PA who had gone to PA school with last week, and at one of the institutions that I'd formerly worked with, we were thriving when I was there. Currently now, they are, I think, 50% less. They are hiring more of another group currently, and they're paying them $30,000+ more. So it is a barrier.
It is a barrier, and when you think about it, if you're a physician and you can hire 2 different professions, and one, you are going to be 100% responsible for that person's actions, and the other one, they have full responsibility for their actions. I'm not, our previous attorney, Michael Scarano, who bled PA blood, used to say that it just killed him to have to tell one of his physician clients that PAs are amazing and they do great work, but with liability issues, you might want to go with their nurse practitioner.
Yes.
So would a possible answer be to change the PA Practice Act to say there is a core set of responsibilities that all PAs are qualified to do due to the nature of their training, right? So PAs trained as generalists, every PA coming out of school can do these things. If the PA Practice Act said if you're doing those core values, you don't need to have physician oversight or co-signature for those core values. If you go to practice in a specialty, or your collaborating physician says that we're going to delegate additional responsibilities, then the physician is responsible for those delegated things. But if that core set of responsibilities doesn't require all of that, does that seem like it would put us on more even footing? Because my issue is that in practice, I work alongside nurse practitioners and PAs. We do the exact same thing.
Exactly.
We get there a different way. Our education is maybe a little bit more rigorous to get there. And I don't understand why we have a regulatory barrier when we do the same thing in practice. And so a change to our Practice Act to put us on more even footing, I think addresses the anti-competitive nature. I'd be interested to hear what you and the other board members or Ileana think about that.
Well, I think you would always have even in that core set of value or skills, you always want to be participating in a team environment with physicians. Never are you without that team physician environment.
Right. I'm talking about the taking responsibility for what the PA is doing with that patient. The PA
Right. You
has
should
his
always
own
take
license.
responsibility. In
Right.
the perfect world, no matter what level you're doing, if you don't feel competent and capable to do it, don't do it. Just like Dr. Bishop wouldn't do something he didn't feel capable to do.
Hi,
Right, but-
I'm sorry, I got to interrupt for a second. And I hate to cut people off, but or at least to jump in the middle of a conversation. But I think I'll say this. I think it's in the board's best interest to really kind of gear this conversation towards consumer protection issues, because we're here as, well, the board, I like to include myself with you guys, but the board is here for consumer protection purposes and not as to protect the licensees, because that's not the board's job. So,
Not talking about protecting the licensees.
or expand, I feel like maybe this should be moved to like a future agenda item if you wanted to talk about expanding the scope of practice or doing something like that. I feel like we're kind of borderline in dangerous area.
It's outside of what was posted on the agenda.
It's, from my perspective, and take it from it what you will, it seems to me like this is less of a consumer protection conversation and more of a how do we help PAs proceed and go forward and get more out of their careers and all of that. And while I think that's great, the board is a regulatory body, so I'm just concerned about the conversation, that's all.
So not disagreeing that maybe we need to make this a separate agenda item or something, but I think this goes back to workforce and access to care, right? So if our regulations are excluding PAs and only allowing nurse practitioners or whomever else falls under these more lenient guidelines, so that the market then, we've excluded this whole profession from the market due to these regulations and the burdens that they require, that creates an access to care issue, which is part of our mission.
I totally agree with you. It just, I feel like that wasn't coming across.
And so we should stay focused on the regs and how.
Well, that's why
my
I
concern is
asked.
similar. My concern is similar. I think that that's why I mentioned the access to care. I mean, this fix has to be legislative. I don't think our regs can do this. So I think the focus is, if this board believes that this is a real access to care issue, we need to kind of get away from PAs not getting jobs for their sake, but it's an access to care issue. Then maybe if we really are serious about this, we should seek a sponsor in the legislature. I mean, the medical board can help us to have legislation that they sponsor with a sponsor. And I think if this board feels serious about this, we should consider telling the staff to start working on getting a sponsor in the legislature to address the access to care issue we believe is occurring because of our regulatory issues. That's where I think we should go with this. If we really feel seriously about it, we should look for a sponsor probably, or have staff look for a sponsor in the legislature to forward this concern.
I agree with you, Dr. Bishop, and I think that in looking at this issue, there should be more evidence provided, more than anecdotal. I think we need to really research this issue thoroughly in order to have a strong case for sponsorship by a legislator. And I understand we're doing a presentation, which, you know, all due respect to council, has taken us to a different level in terms of talking about workforce issues. And so I just wanted to put that out there as well.
the AAPA is doing. They have a task force. They're doing surveys. They're doing all the research. They're going to bring this to their House of Delegates in May. So certainly we'll have more information and more
That's great.
feedback in May when we see what their resolution to the House of Delegates will be on a national level.
And I think also you can grab extra information because adding a little bit more about your comment about getting some family packed trainings. So it was very hard for me to send my PAs for family packed training. There is a very important training, especially working in a community clinic. And I wasn't allowed to send the PAs. Only NPs and MDs and DOs were allowed to attend to those trainings and get a certification to be approved to prescribe those type of medication or provide those type of services. So there's many PAs that they have this type of issue. On that time, I was overseeing probably more than 18 PAs, and I wasn't allowed to send any of them for that type of training. So that
and that
decreased.
is an access to care issue when they can't
That's
treat that
big.
population.
That's a big issue to provide the type of services. Even that I was associate medical director at that time, I wasn't allowed to attend to those trainings, even though I was the senior PA trying to train all these other PAs that I just hired. So it was kind of difficult. So I had to hear the information for the MD supervisor or for the medical director until they can go for those trainings, train me, and then to train the rest of the staff. So, and that's happening in, I'm pretty sure, many clinics.
Also, we don't know what the new healthcare legislation will look like, so we may need to further look at how we might be impacted or may not be impacted by what we're able to do in terms of healthcare legislation.
And I think as a membership association, our intent today was to kind of let you know what our members, your licensees, are reporting back to us, and just sort of, give you guys a heads up about different changes that, are going on in different states and some of the,
We appreciate that because we know that it's happening as PAs. We know that it's happening, and it's happening even more rapidly, but it makes a lot more sense when there's other states that are included in that. So thank you so much.
Thank you for your time.
Further comment from board members? So I
Could-
just ask,
Could we add this as a future agenda item?
yes. Yeah. I think it's-
Jed, as such, would you consider suggesting to staff that they provide us with additional information if it exists in terms of impact on workforce and those sort of things, if that data exists at all? Impact on access to care is what I meant to say.
I think I feel terrible asking our staff to do more stuff.
What would Kappa
If I
know
could amend
that
that, I
information?
mean, why don't we wait 2 meetings and get the report that's going to be available in May, and just discuss this at our summer meeting?
Actually, yeah, that's fine. But Dr. Bishop, I wonder if you might ask the medical board about their thoughts on this, in terms of having equal responsibility with our nurse practitioner colleagues in terms of oversight and what their feedback is.
I'm just not sure if that's an appropriate. As I said, we're in a quite a difficult area because we can't be seen as advocating. The PA board and the medical board are never in a position to advocate for any group or against any group.
I'm not. That's
I
not
know,
what I'm
but I'm just. I know you're not. But I'm saying it's difficult to separate that out unless you couch it in the terms that you truly do believe that there's an access to care or quality of care issue. Those are the mandates that we have as state boards to ensure the access to care and quality of care for our public. You can't couch it in terms of well, our PAs can't get jobs, or our neurosurgeons or our anesthesiologists getting run out of business by the CRNAs. It has to be couched in those terms, or you really can't bring it up appropriately in that meeting. It's not going to go over well, I can tell you that. I know I was suggesting, I was talking here with Ileana, I was saying, I don't think this discussion would have gone this far at the medical board. It would have been stopped. Because and I agree with your concerns, but from our mandate is slightly different, and it's subtle. And as you know, I'm a strong advocate for the PA practice, but But I think I will certainly report that this issue was discussed in our board. But I certainly could. Somebody could come in as public comment as well and ask to have this as a future agenda item. But I'm not sure that I have enough evidence to ask for that at this point in time. With all due respect and support.
And would Kappa have any information in terms of that information? I'm not sure.
Yeah, report coming.
But I'm just saying before that, do they have any demographical information? Or?
I'm sorry, what type of information?
The information relating to, I think all the things that we just talked about in terms of, I guess, do we have any information regarding access to care, decrease in access to care for physician assistants in California based on that information?
Well, I think that it's a fine line. I mean, because if MPs are filling that role, then there's probably not a measurable decrease in access necessarily. So I think we have to be thoughtful about how we look at it. And I think you're absolutely right in terms of the regulatory roles. Scope of practice is not something that at the statutory level that we would that you guys would probably engage in. It's sort of like sharks in ice water. You don't want to get in it, and if you do everything you can to get out of it as fast as you can. It's just not as consumer protection. And if I'm understanding what you're asking, that's a different charge than, say, an association looking at that role. Right. So I don't think I could offer what you're asking for because I don't think it exists. But I think that we can say that there are workforce issues. They just maybe don't result in exactly that. If, and I say this with the if they're actually being filled by NPs. Does that make sense?
Mm-hmm.
Okay, so I think we'll put it down as an agenda item, probably for the rest of the meetings this year, to establish a plan to move forward, maybe with some DCA-sponsored legislation, or if CAPA wants to do it. I think we have to keep in mind that if we do a statutory change, ultimately it will require a regulatory change also. So they're two separate issues. And that would mean we would be opening our regulations up again. So give this an appropriate amount of time at the next meeting. Any more public comment? Okay. I'm gonna skip around again. We're gonna go to number 20, which is our budget update.
Well, mine are in black and white, but
Hers are probably in red.
Good afternoon. I'm Marina O'Connor. I'm with the DCA Budget Office. Thanks for letting me speak with you today about your budget and any questions you may have. Right now, just passing around your expenditure projections. I apologize for you just seeing these right now. Usually we do try to get these to you in advance of the board meeting. So maybe if you'd like, we can wait a couple minutes for you to take a look at them. But what's in your board meeting packet, I believe, is just the fund condition, right? Okay. So we can go over the expenditure projections first, unless anyone has a preference. Just want to make sure. So everybody has them now. Okay. Okay. So The document that was just handed out, those are the expenditure projections for your board. Before, you know, I'm sure one of the biggest questions you'll have is at the very bottom, you'll see right now there's a projected deficit. So the main reason for that deficit is if you look at your Attorney General and Office of Administrative Hearings budget line items, are towards the bottom, you'll see that you're going to need probably a current year augmentation for AG and OAH because you're projected to go way over that, your current budgeted amount. So that's something we can do. We have the authority to request a current year augmentation, and the time is to do it now. So we'll work with Lynn and, you know, her staff, and we can submit that request on behalf of the board to make sure you have sufficient funds for the remainder of the year for your AG and OAH. Now, assuming we did get that request in and get that augmentation for your AG and OAH budget, you'd still have a slight deficit. So the other line item I want to direct your attention to is kind of towards the middle of the page. It's CNP Services External. Now you'll see there's the projection is about $111,000, which is equal to what your year-to-date expenditures are. Now that's because we've encumbered the full amount of specific contracts that are in that line item, one of those contracts being the Maximus contract. Now last year, if you look at the prior year, you ended the year with way less than what you had encumbered. So you had actually liquidated large amounts of those contracts that year. So if you end up spending similar to what you did last year in that line item, you'll end the year easily in the black with a positive, so with a surplus. So the assumption is that you probably will end up liquidating a large amount of that contract, but we're going to have to work closely with the board and working on those projections to make sure that that's how it looks like the Maximus contract spending is going. And right now it does. I believe year to date specifically on that contract, there's only a little over maybe 2,000 expended. So you're on track right now to really actually revert a lot of that budgeted amount. So with those two assumptions, that you get the AG and OAH augmentation and that you don't spend the full amount of your Maximus contract, then you actually will end the year with a surplus. So those are the main items I wanted to point out. Do you have if you have any specific questions on this, or if you want to look at it a little longer, you can ask me later and I can move on to the fund condition if you like, unless, yes, yeah.
I think earlier we stated there was going to be some additional staff hiring. Is that going to affect the budget?
And this is for this year? Yes. Okay. It could. It just depends on classification, when the hiring will take place. Because this budget, or I should say these projections for your civil service perm, those assume current vacancies that will remain. So, you know, we would have to discuss with the board when those positions would be filled. But most likely, since we're already in January, unless they were going to be filled right away, it probably wouldn't have a huge impact.
I'm shooting for February 1st on the part-time
Okay.
position that
Okay.
we have. Probably March 1st for the vacant AGPA position.
Okay. Yeah, so we can, of course, build those into our projections and see how it's going to affect your bottom line. And I should reiterate that we do focus on bottom line. We don't do line item budgeting, which is why you'll see for each line some negatives there, because we're focused on your bottom line budget. However, that doesn't mean, you know, if your spending changes in one line item, you're spending a lot more than you have before and a lot less in another line item, we can't make those adjustments to your budget to reflect more accurately your true expenditures. We can always make those adjustments if that's a concern, or it's just better for tracking purposes. But we do focus on bottom line, so we can build those into your projections, and we can build in those other assumptions about how some of the other contracts are looking and see what it would look like for the rest of the year. But looking at, again, those contracts that haven't had much expenditures on them and probably won't for the rest of the year, I think you're going to have some cushion. Yeah.
I have a question about the Maximus contract. I
Yes.
thought the the physician assistants that were cited, they paid for Maximus, or is it?
I'm going to be honest, I'm not too clear how the payment works, but it is a contract with the board. And I don't know, as the board, the licensees do they? I'm not, maybe Lynn can answer that.
New
better.
licensees going into, the new licensees that, thank you. Okay. Anybody new going into Maximus, they pay the cost themselves. We do not pay it. The
Okay.
older, Anita, do you want to chime in?
We do pay.
I know we do. That's where I was, huh?
We do pay a portion of even the new ones,
Okay.
because we haven't reviewed the contract, we haven't renewed the contract yet with Maximus. So we are still required, based on the original contract, whether there are new intakes or not, we still pay a portion for Maximus's services on top of what the participant pays.
Okay, so it's probably just a matter of looking at what that portion is that you pay and how many participants, and we can come up with probably a more accurate projection of what we anticipate paying for the remainder of the year. Yeah.
Thank you.
Question, yes, about the enforcement items,
Yes.
the overage there. What it accounts for that overage, and how do we address that in the next budget year?
As in, like, you don't mean specifically like which cases or?
No, but I mean, it's quite a bit more than
Oh,
that
I see what
for
you're
which
saying.
we were budgeted.
Right, right.
So, I think there's both a question around why is it so much more, but then also how do we communicate with the administration about what we need in future years,
Right.
like if this is something that's going to
Yes.
continue.
Yeah, and I think this is something we've kept an eye on with the board is the last 2 years you've had to request a current year AG augmentation. So this being the third year we're going to request it in a row, I would think that that is grounds for a trend, in which case, you know, if the board wishes, they can pursue a BCP through the normal BCP process to request an increase to your AG and OH budget, which is a completely, you know, standard way of requesting that increase. You know, especially having the 3 years to say, well, this year plus last 2 years, we've had to request this. We anticipate this to be an ongoing, you know, trend. Then, you know, that could be justification for a BCP, which is a budget change proposal.
Can our staff file a BCP, or do we have to do it by, does the board have to request it?
That's a Lynn question. I don't have
Okay.
I have no idea.
You can direct us to start the process. We'll get a hold of budgets and we can get it going.
I mean, this is the time, so.
Yeah, sorry.
I'd
go
have
ahead.
to agree, especially based on Gloria's presentation to us with, you know, the advent of the breeze and taking in more complaints. I think this is going to be a norm for us. And she said she's willing to work with us. So if we see this as the trend, I think Catherine's right. I'd second that motion to start working on this and get it aligned.
Okay, well, we're still discussing the report. We haven't even taken a motion yet.
So just
I can,
Yes, it is a motion.
Oh, okay, well then,
I'd second.
all right.
do we want to, okay, make the motion.
I move that we direct staff to start the process of filing a budget change proposal with the governor's office
Second.
for an augmentation to our annual budget related to enforcement activities.
I think we need both, don't we?
Yes, I'd have to go back and see if, I don't know if you had an OAH augmentation last few years or not. I'd have to go back and check. But it could be for both if you want it to be.
I just said enforcement activities because
Yeah.
here, the way you've got it listed, AG and OAH are
Yes.
both under enforcement.
Okay, and Mary? you
Second.
Okay, further discussion? I can share that I met with Gloria, I guess about a week and a half ago, and she gave me a rundown on some of the cases, and I'm sure Lynn has this information also. One of our enforcement cases cost us $102,000. That's one person. And we have 3 or 4 that are ongoing that are costing us that kind of money. And to sit there and look at our total budget of $1.6 million and we're spending $700,000 on enforcement, it's time for a budget change proposal. And you know, we deal with this every year, and it's like we get down to 2 weeks before July 1st, and we still don't know if we're going to be black or red. And that's an ineffective way to run a business or a board. And Xavier he used to have a lot of hair on his head, now it's all gone. Because of the financial situation with this board, and I think we have plenty of money in our fund, and we need to get some of that transferred over to handle the enforcement. Because the trend is, I mean, we heard this morning, we're doing over 100 complaints a month.
Yeah.
That's 1,200 complaints a year. We only need 2 of those to go to $100,000 apiece, and we're toast.
Can you be a little bit more specific in terms of enforcement? What are we talking about? Number of hours, or what type of case, or?
Some of it is cases that have gone to the administrative law judge. They've come back to us. We've voted on them. We've agreed on a discipline. The PA does not agree on it, takes it to the next level where the Attorney General is still our attorney.
Do we pay them by hour, or is it on ongoing?
Hourly basis.
It's hours.
It's hourly.
But if they have to go to Superior Court,
Right.
and then after Superior Court, it goes to a writ, all of that is money.
Okay. I just wanted to.
Yeah, and Gloria is, in the meeting that I had with her, nothing is slipping by her. She's watching every penny that we're spending.
Right.
And doing everything she can.
I just didn't have a conceptualized
To the
view
point
of-
that she just hired 5 paralegals to try and cut the expense down a little bit with the Attorney General's office. Now, whether or not we will benefit from that is unknown. But our enforcement costs are only gonna go up if we do our
Right.
job appropriately.
Exactly.
If we put someone on probation, in all of our orders, we have cost recovery. And every time an AG will call the office and they want to do a settlement conference, one of the things that comes up is, can you cut or can you back off on your cost recovery? Answer is no.
No.
I want all of it, and here's why I want all of it. In some of the cases where the one that Bob's mentioning, the license is revoked. He filed a writ against us, and it's going through the process. Chances are we'll never get that money back. Only if that individual applies for his license to be reinstated would we stand a chance of recouping that money. So that's $100,000 we're never going to see again. So that's part of our issues.
Wow.
And that's
Thank
only
you.
one case.
Yeah, that's one case.
Thank you for explaining that.
It's ugly.
It is.
I have a follow-up question.
Yes.
I know you guys budget based on the bottom line, but it's nice to see budget items for each line item so we can compare. And I'm looking at the minutes for October 24th, and it says budget update. Mr. Martinez requested that the analysts use the year-to-date numbers as a budget number so the board can track whether or not the budget is actually online, and also requested a monthly budget update. So this was back in October. I requested that if you look at this report, there's items there with actual numbers but no budget. And my experience over the years is when you do a budget, you do line item by line item, just so you have an idea whether you're positive or negative. So
Are you referring to the budget report for FMO5, the one in the board meeting packet?
this one.
Yeah, that one does actually show your budget for each line item. And
Okay,
our,
so I'm looking at
He's
one
got
item.
06.
It's,
so you have 06, okay.
Yeah, I just got it, so I copied
Oh,
and
no,
gave
that's
it to
fine.
him.
Yeah, I
So,
mean, it's the same report, just more
It says,
updated.
For example, under staff benefits, other staff benefits, 0 budget, current month 793, year-to-date 4106. So there's no budget item.
Oh,
for
you're
that.
talking about some specific line items that you spend against without a budget.
I know you do
right.
guys look at it in total, but
Right.
for us, it'd be nice to see each line item.
So we can do that. That's getting down to very specific, detailed line items that you may or may not have expenditures against in any given month or year, for that matter. But we, as you can see on our expenditure projection, we roll up a lot of those line items, either kind of like how they're grouped in that budget report, right? So some staff benefits rolled up into certain line items. Changes to that report, by the way, you're looking at the budget report, that's a CalSTARS report. We're actually transitioning to a new system, the FisCal system, so that report isn't going to look anything like it does now when we go to the new system. I won't say anything. You'll still have your budget, your year-to-date. It's going to be different codes. It's going to be different line items. This, I have to forewarn you, this is all changing. Yeah, next year. Yeah, this is the last year, and CalSTARS will be completely over in FisCal next year, so your reports are going to look line item by line item slightly different codes, et cetera. It'll take some getting used to, of course, for all of us. But the expenditure projection, as you can see, is rolled up a little bit more, but we can work with the board on moving, moving your budget around a little bit, let's say in OE&E, to kind of better align with your actual expenditures. For like the example you said, if you spend up to 1,000 every year in this one line item, you have 0 budgeted, I'm sure we can find somewhere we can move 1,000 over. So it's just a matter of working with the board on making those adjustments, however, whatever works for you guys. And I just have to say again, because we're going to be in a new system at FisCal, I don't know exactly how that's going to work in the system, but at least for visual presentation, we can do that. That's fine. And this might be getting too much into the weeds, but I just wanted to say what we, I don't know, I can't speak to the reports you'll be getting because that's a whole new system. So your reports may be one thing, but we can always work with you on getting you something that's more appropriate for your board meeting or just for monthly tracking. Not a problem at all. So I just can't speak to the report you'll have in FisCal because we don't know what it looks like yet. So.
How long does it take to, I know Catherine and Mary just had the amendment, how long does it take for that amendment to be processed or approved?
Sorry, which amendment?
I think Catherine just mentioned the budget, right?
Oh, the BCP. Right. So that was something I wanted to clarify. Is we just finished the 17-18 governor's budget just came out. So 17-18 BCPs that process is over, right? That's already governor's budget out for 17-18. So you'd be looking at the 18-19 BCP process, which. I can't say exactly when we start working on that. I want to say you've got a little time before we'll send out the request for, you start with the BCP proposal. It's actually quite a long process because it's part of the governor's budget building process. So we start pretty far in advance with the programs and putting together, whatever proposals they want. And then, as we build together a final BCP. It goes through, multiple levels of review before it actually becomes part of the governor's budget. But I think we have a little bit of time before we even request those proposals. So
6 months, 3 months?
Before we actually start working on it, I think at least a few months, I want to say.
And then the process takes 6 months?
It can take, I'd say at least 6 months. Yeah, I mean, until it actually is part of it, because the governor's budget, right, when it's released in January. So, all the reviews it goes through, it can take about that long.
So now that we made that, is it on your docket now to do that for next year?
We can put it on it'll be on our docket as far as when we send out the request for the proposals. If we don't see something from you guys, it'll be a red flag. Are you guys, and then we'll ask, are you planning on, submitting a VCP just to make sure nothing's changed, right?
Is there any limit on how much the augmentation would be for a specific category?
I can't. It's usually, we usually look at the trend. So the last few years, how much you've requested in current year augmentations, and you can kind of project for the future a little bit, but it's going to have to be very close to what we've requested in prior years. Maybe looking at to see if there's been any kind of fluctuation, but I think you guys have actually just steadily gone up. So I wouldn't say there's a limit, but you have to have the data to back up the amount, of course, you're requesting and the justification. So, we look at the last 3 years. On average, we've requested this much. It's increased the last 3 years, et cetera, and we can come up with an amount that seems appropriate. And that doesn't mean that if you request a BCP and you have your budget augmented, and for whatever reason you get another, very expensive case that hits, and you again have to request a current year augmentation, that's okay. You can still do that. Because again, obviously, if your costs keep going up, then maybe you have to just every few years, maybe it's another BCP, right? If it goes up that quickly. So I wouldn't say there's limits, just as far as what you can justify. Okay, any other questions on expenditures? So we can go over the fund condition, or
no, we need a vote.
Oh, sorry. Yeah.
So any further comment? Public comment? There seeing none, I will call the vote. Dr. Alexander?
Aye.
Jennifer Calquist?
Aye.
Sonia Early?
Aye.
Xavier Escobar Acosta?
Aye.
Jed Grant?
Aye.
Catherine Hazelton?
Aye.
Xavier Martinez?
Aye.
Robert Sachs, aye. Mary Valencia?
Aye.
Aye. Okay, so that carries. Okay. Back to
Okay,
you.
the fund condition, which was included in your meeting packet materials. So this shows 4 fiscal years, your 15-16 actuals, your current year budget, and then the 17-18 governor's budget, and then we projected out one additional year into 18-19. So 15-16, 16-17, 17-18 directly reflect what's in the governor's 17-18 budget. And as you can see, if you just drop down to the bottom, your fund balance and months in reserve, your fund is doing just fine. There's really no concerns there right now. So I don't really have anything else to point out on there unless anyone has any questions.
I guess I'll ask the question I ask every meeting. Is there any idea when the loan is going to be repaid?
Typically, it would be repaid when there's a need for it. The standard is to not let a fund balance go below 3 months unless there's some other statutory requirement. I would say requesting the loan to be repaid anytime soon, if you're still in the double digits, is probably not going to happen. There's also the standard of if you need it, they have to pay it back.
Okay.
So, but was that something you guys were concerned about, or?
Well, last year we were actually concerned because we were sort of given some information that we might be getting the 1.5 or 1.6, whatever it is, this fiscal
Oh, okay.
year.
Of course they can pay it back whenever they
And
want to, and if you don't need it right away.
The problem that was going to do is
Yeah.
it was going to put us over the 24-month maximum.
Oh,
which
okay.
would have made us,
We can always, if that's the case, we can request for it to be delayed, if that's the case.
okay. Further questions from the board? Okay, thank you very much.
Thank you.
Tell Wilbur we didn't pick on you.
No, that's fine.
Okay, I'm lost. Got everything on the first page. So I guess we will go to regulations, item number 13 on the agenda.
Before I give my regulation presentation, I'd like to remind the board that the department has changed the procedure to have regulations approved. Previous, we would be able to put our 45-day notice together, submit it to OAL, have them post it, have our hearing, and then submit the final package to the department and to Business Consumer Services and Housing Agency. They did not renew with OAL, and we are now required to submit our 45-day notice to the Department of Consumer Affairs and Business Consumer Services and Housing Agency before I can have OAL post the 45-day notice. So that is why it is now taking quite a bit longer to get our regulations approved. Preface it. Moving on, 1399.573, I have submitted to DCA and agency for approval. I submitted it back in December, have not received it back yet, just to give you an idea. It can take up to 60 days to get them back. I am trying to give them an idea of when I want to have it posted, so I'm hoping to get it back before February 24th so that I can post it with OAL, and we can have a hearing in our April meeting for that particular one. So that's where we stand on that one. 1399.546, it is finalized. It is with agency for review. They've had that one since November. Until I get it back, I cannot file it with OAL. Once I do get it back, I will submit it as soon as possible. 531 and 532, the repeals. I've been doing some research. I found a wonderful study put out by CHIA, by the way, that talks about the requirements to be a agency that would review specialty or approve specialty trainings, and what their feelings were as to what you needed. So I am incorporating that study into the repeal of the regulation. So I've gotten the initial statement of reasons done, and I'm working on the notice. So I'm hoping to have that done by the end of the month to submit to agency for the 45-day notice. So we will probably have our hearing for that one in July, or our meetings in August. So it'll be the August meeting. I'd like to skip over D, which is the retirement status, because Ms. Hazelton requested the cost to apply for if we could charge to process the retirement. So I did I included the statute and the regulation that gives us the right to charge fees. And neither one of those list, I mean, they're very specific about what we could charge. So if we wanted to charge, we would have to change statute as well as reg. If we wanted to charge, it would be a $10 fee based on how long it takes us to open up their account, change their status, and close their account. And then scan their document. When we charge $10 to do a verification letter, it's basically the same procedure. What I did do was I ran a study on our first 11,000 licenses that we issued. Out of those 11,000 licenses, we have 103 that are delinquent, which means they've decided not to renew, and we have 248 that are current or current inactive. So we're probably looking at 350 licenses that might want to go into retirement status in the influx in the beginning once the retirement status is done. So we're looking at, what, $3,500 as revenue? Is it worth the additional time to change legislation and to change reg for $3,500?
Can I ask you a question? Because I wasn't at the October meeting and I haven't, frankly.
I wasn't either, so okay.
Oh, okay. Well then. Well, then we may have to come back to this. I thought that there was a government code section that Christy was referring to in terms of the board being able to charge. So I don't know that we would have to do a statutory change. I would need to look into it. So far, I haven't. I need to talk to her because if she knows it off the top of her head, I'm not going to go crazy trying to find it.
I know our statute is
absolutely
3521.1.
Right, but there might be an additional statute outside of your Practice Act that would say boards need or government agencies need to charge blah blah blah.
She did state, from reading the minutes, she did state that government code does allow us to recoup any costs that we might incur.
Right, so I need to look at that specific language to see exactly what it says because
we might not have to do that, but we would still have to do a regulation change.
So give me, if you could be so kind to give me a little bit of flexibility to find that statute and look at it and see what it actually says, and then we can go from there.
Right, but my question is though, is the $10 that we're going to charge for this application worth it to us to do?
I mean, I think we went back entirely on you. I think the initial inquiry was about, does staff need this support in order to be able to do this work? And if you don't need those resources, if it doesn't make financial sense, then skip it.
To me, it doesn't. I mean, we don't charge to change somebody's name. We don't charge to put somebody in an inactive status. We don't charge somebody to give them a CE waiver. The only thing we charge are initial applications, renewals, and verification letters. That's what we charge for.
Can I ask a question?
Yes.
For the 350.
I'm sorry.
For the 350 people that are outstanding, does the board have a way to? Are they notified when somebody dies or something like that?
Yes, that out of the those are those are 350 that would actually might benefit from this retirement status of the first 11,000 licenses that we issued. So
Right.
what I did was I did a printout of, I asked Breeze to give me a printout of the first 11,000 licensees
Right.
and their statuses.
Okay.
So-
So Breeze calculates who's died, who's,
Well, we have the once we get if we get a death certificate, we go in and change their status to
Okay.
deceased.
okay. No, I'm just
Okay.
wondering, do we
But-
automatically receive those, or how do
No.
we get those?
Normally, if, let's say they've kept active, when the renewal notification comes out, next of kin calls, says, my husband has passed away, we ask for the death certificate so we can put it in their file.
Right,
That's
okay.
how we found out.
Okay. All
But
right.
most of these have been canceled.
Okay.
Because they don't renew, 5 years go by, and their license gets canceled.
Okay.
You know, but we do have a lot of
Right.
licensees that have been licensed for 30 or 40 years, and
Right.
they want to retire, and they don't want to, they don't
Right.
want that delinquent status, so they go current and active.
Okay.
Those are the ones that we want to make it nice for them.
Excellent. All right, thank you.
Yes, sir.
When's the last time the physician assistant fee structure was reviewed?
Julie's were up for the initial application?
I mean, just in general, I mean, I'm looking at this regulation, when's the last time it was actually 1399
550?
Yeah,
1983.
19 what?
83, I believe. I don't have that one with me.
Well, I didn't see it in the history, that's why. And you normally see history, you have a date, but there's no dates here.
Let me see what I can find.
I think it was initially established when we did our regs.
I think it was 1991 when we did our most recent big rig changes, and we're at the maximum at this point that we can charge for a license. So that would have to go to the legislature. And I'm not too sure the legislature would embrace that.
Is that fee consistent with other boards?
I did look at all the other allied health boards that are part of DCA. None of them charge for retired status except for the pharmacy board, and the pharmacy board charges $45. But none of the other boards do. The medical board, the nursing board, vocation, dental, nobody charges to change your status to retirement.
Okay, we need to move along here. It's getting late. Can we go to the next rig, please?
The Business and Professions Code 515, this is for retirement status. It was reviewed last time. Christie made some changes. I did make the proposed language changes that were recommended by legal last time, as well as the proposed changes to the application itself, which would be incorporated by reference. So if there's no discussion, we can approve the regulatory text and form number and submit it. I mean, do you need me to read the recommended action or to have a discussion on the actual language? Does anybody have any changes or updates?
Do we have the actual language in our packet?
Should be, the
language
language
is
is
in the package, sir.
yes.
Yes, 13D.
Yeah, it's in here.
It should be in there.
Print's too small.
Yeah, I see, yeah, I see it. Go down.
Let's go back.
Have you read the language?
Should be
That looks fine to me.
Okay. So do we don't need, do we need to make a motion on that?
Yes.
Okay, so has everybody read the language on 1399 515?
So this was,
Okay. So the recommended action is to approve the proposed regulatory text for 1399.515 as revised, or I'm sorry, and revised form PAB-RET October 2016 to direct staff to submit text to the Director, Department of Consumer Affairs and Business Consumer Services and Housing Agency for review, and if no adverse comments are received, authorize Executive Officer to take all steps necessary to initiate a rulemaking process, making any non-substantial changes to the package and set the matter for a hearing. So does somebody want to make that motion?
So moved.
Second.
Thank you. Further discussion? Public comment? Okay, or call the roll. Dr. Alexander?
Aye.
Jennifer Carlquist?
Aye.
Sonia Early?
Aye.
Xavier Escobar Acosta?
Aye.
Judd Grant?
Aye.
Catherine Hazelton?
Aye.
Xavier Martinez?
Aye.
Robert Sachs, aye. Mary Valencia?
Aye.
Okay, so you are so directed.
Okay.
Okay, back to Anita.
Legislative proposal. I believe at the last board meeting, we had to approve the exam scores and the places of the exam. With the help of Ms. Butu, I was able to put up some proposed language to change statute. The proposal is to change it. I have to put a proposal together to submit to the State Senate Business Professions and Economic Development Committee. So the first page that you have in your agenda was a little brief background of it. And then I put a draft together that I would submit to the committee. And I would really love some input from the board as to if they can make any recommendations to what they would see to help this proposal go through.
I had a couple of thoughts looking at it. First, I'm glad you mentioned business and professions. Were you asking to be put in their omnibus bill? Have you talked with them about
I
that?
did talk to the Department of Consumer Affairs Legislative Committee, and they told me that it was too substantive to be.
Substantive.
Thank you. To be omnibus.
Oh, bummer.
And they also thought that it's possible that they were worried about an underground reg. But because she thought I was basing it only on 3510, which allows us to write a reg, not realizing that we have a regulation that incorporates the NCCPA as our examining committee. So once I pointed that out, she was okay with it. But because we're actually stating an entity within there, it could not go in omnibus.
Well, I wonder actually, I mean, obviously you want to try and get it in omnibus if you can, because it'll reduce your burden so much. And I wonder if one of my comments might help with that. Okay. I really thought that this should be more generic without naming pants. That it is. Do you say it that way?
Yes.
Okay. That that the because that could potentially change, because they could no longer be the certifier of record, and then you wouldn't want to have to go back and change legislation again. So, so you may want to write it so that it's a nationally certified test, or or a test accepted by the physician assistant board as the certification. Define what that test is and make sure that pants fits under that. But give yourself flexibility there so that you don't have to go back and change the law if they fold or if you no longer want to work with them. Does that make sense?
Yes.
Yeah, okay.
Yeah,
and I think you might want to write this in such a way that you say that keep in there the language that the physician assistant board shall set the date and the score, but then say unless they create the exception there, that there's a provider of certification that that already does that. And the reason for that is if, for instance, you work with a new organization that doesn't actually set a threshold or doesn't actually determine what the date is, you would have to go back and change legislation for that too. So I think what you want to do is create flexibility here so that if for some reason you start working with a different certification organization, you can still accommodate their practices.
Okay,
Does
so,
that make sense?
right, what we want to get away of is us approving the score
Right.
on a yearly basis, but still accept what score they set.
Right. So you can say that the PAB would approve the score and would set a date, or shall do those things, unless there's this organization that
Unless
certifies
Unless
already
set by
does
the
it.
certifying
Unless
organization.
right, exactly.
That's what it was at.
So is that going to be a motion?
Well, let's think about what the motion needs to be. So do we need a motion for the staff to be able to work with committee on a bill, or do we need a motion are you just looking for input, or do we actually need a motion to give you formally this input?
So we don't want to approve this language. You want me to come back with newer language and
I would
different,
recommend
that was more flexible and more generic.
Yeah.
Okay, so,
But let me just say, given
Okay.
the calendar though, we're not going to be meeting again until April, and policy committees will be well underway and close to finishing up their business at that point.
I don't
So
think
we don't
this
want
is
to hold you
getting-
back.
Yeah, I don't know. I can work with the legislative committee at DCA.
Uh-huh.
They're very willing to help me with this.
Uh-huh.
So what I can do is I can put some different language together and email it to you for your opinion. Can I do that? Am I allowed to? Because she's on the legislative committee, can I email it to the legislative committee, which is only 2 members, which means we wouldn't have to do a posting, correct?
Yeah.
Okay, so, because.
Because you're going to hit your deadline for bill introduction very soon.
Right, so I can work on this and email it and ask for your opinion based on that. If the board is in agreement with that, if I work with just the legislative committee on getting the verbiage down to make it more generic and more flexible. If the board is.
I'm just kind of curious, what is the end result of working with the legislative committee? Because at some point, the board has to look at this language and approve it.
Does it before it can go to the legislature?
I think so, yeah. Because it's really, a committee of 2 people can't really act on behalf of the entire board, and especially this is kind of a big deal. So I don't know that I'll look into it to see if it's possible, but based on what I know right now, don't think it's a good idea. I mean, it's great to, yes, communicate with the legislative committee, get the feedback, do all of that. But I think ultimately it might need to get board approval before it actually goes further.
So given that, I think I still would recommend that you work with us on it, because then we can iterate, which is harder to do at a meeting like this, on specific language. So we can iterate on something that we bring back to the board. But since that meeting isn't until April, unless we can amend this into an existing legislation, it's not going to go anywhere this year. So it would be next year before anything happens, probably.
I don't think that's a big problem if we don't get it done this year, as long as we get it done next year.
I agree. I mean, I'm not on the board, but I do think that, it's one more agenda item for one more year, and then it's done.
Okay, so I'll be in contact with you then.
Great.
Okay. Thank you.
Potentially could be changes in, national health care law that we would want to incorporate.
Right.
Okay.
I made comments, but I don't know if anybody else wanted to.
Yeah, you want to do that now?
No, I didn't know if other board members or public had comments on the topic. I just wanted to know. I was the only one who talked.
Yes.
I have a comment.
Oh, come on.
Thank you.
I'm Dr. Tracy Montez, and I'm the Division Chief of Programs and Policy Review at the Department of Consumer Affairs. One of the units in my division is the Office of Professional Examination Services, and we often work with boards and bureaus on language like this. There's actually Section 139 of the Business and Professions Code, which mandates all the boards and bureaus to have psychometrically sound examinations, even when they're using national examinations. So we certainly can help you with some language if you'd like. And we'd also like to use this as an opportunity to introduce the notion of sometime doing a review of your national exam. And what that does is it provides you with the due diligence that the national program is meeting the highest level of psychometric standards, which then means that you don't have to, again, review and approve passing scores and all of those things because your board has examined their process and it meets all of those standards and guidelines, and you can feel confident that they're doing what they're supposed to do. And in the event if something were to happen, it does give you an out to go to another organization or to develop your own exam or to have some alternative. And again, we've done this for the Dental Board, Board of Behavioral Sciences, most of the boards that use national exams, we've looked at those. So just want to offer our assistance and let you know that we do have this wonderful little consulting firm within the department, and we work very closely with Ledge and legal. And again, it's just a nice team effort to provide you with data that protects you against any challenges against your exam program. So thank you.
Thank you very much. Public comment?
I was going to say that during our earlier discussion about the PANCE and the PANRE and recertifying, AAPA is looking closely at not using NCCPA. That's kind of in flux. Maybe that's going to be fine. But that could change within the next year, who is going to administer this national test. So, and we all know the NCCPA doesn't like you looking at their tests and doing all those things. But I think if the language can be flexible, it would be so smart for it to be flexible, and maybe it can't.
Thank you. Further member comments? Okay, so do you want to finish your Ledge report?
Oh, sure. Yes, let's move on to that.
Did you want to talk about the
Initial licensing.
initial licensing increase?
Pardon?
I don't think we're done with that.
That was,
No, we did
that
the
was
application fee for
item F.
retirement, and then you had requested that we come up with the actual cost of processing an initial license, because we only charge $25, and whether we want to increase that fee or not. So that would be a regulatory and a statute change as well, because statute says we can charge up to $25, and regulation says that we will be charging $25. So if we want to change that, we would have to have regulation, statute change to say up to a certain cost, and then change the regulation to incorporate what cost we want it actually.
What item number is this?
This is item 13F, and there's a spreadsheet in your packet that we're using right now to perform a desk audit study.
Turn that over to Julie. She's running that study.
We were directed by the board in October to do the desk audit study. So we developed this about 3 to 4 weeks after we came back from the board meeting and started attaching it to the initial applications that we were processing. And it's a slow process to complete an application to see how many, because we don't want to attach them to every single one. We're just doing a random. I'm doing like maybe every third application that we receive, I'm attaching it. And so I haven't really had finished product to do like a multiplier for the position of the individual that's going to be doing most of the work for reviewing the applications to kind of see what the average cost should be and increase the fee if any. So right now we have about 10 or 12, and I didn't really think that was a sufficient amount of people to do the multiplier with. So I'm hoping by the next board meeting we'll have some, a really good set amount that would justify an increase. But I didn't know if anybody had any questions or just wanted to bring it to your attention that we are working on this.
If I recall correctly, this is really in regard to fees, but also with staffing, right? Like how, do I recall correctly? Is that right?
We wanted to see if we needed to increase our application fee. of the $25 to see if it was in line with other boards that were licensing physician assistants, if that was comparable, or, I mean, you know, just to see if it needs to be increased based on how much time it's taking. So we have minimum applications that really don't warrant more than that, but then we have a lot that will have multiple phone calls. We have to hunt down supporting documentation, or you have a review that goes to the AGPA, that goes to the executive officer. Then we have to get the further legal counsel on that. So we have to kind of compound all those costs in and see where we really should be at for charging our application fee. So that's what we're doing in the city.
Well, I appreciate you putting this together and starting on it, certainly. I'm sure, I don't want to speak for the board, but we know your guys' workload is very heavy right now, so thank you for getting started and working on it even now.
You're welcome.
Okay. Jed, do you want to do number 17?
Sure. Would it be okay to take a quick biologic
Yes, we
break?
can take a 10-minute biologic break.
Thank you.
I don't know what the first flight out is. Usually the pad.
That's okay. I was like, all right, let's rock and roll. Okay, let's get this done. Right? I don't know how either.
So anyway,
I was just rolling with it.
I will make the announcement about that. Mary has consented to do it. So you do your thing and then.
But right now we're doing
Mom, I thought I heard you say Mary has been sentenced to
Yes.
serve.
Same.
Exactly. So it actually fit right there.
Yeah, I need a form, so you're good.
You may start.
Oh, wait, we're missing,
Go ahead and start.
Yeah.
Okay. So at the President's direction, I'll go ahead and start. So this is the update from the Education and Workforce Development Advisory Committee. So in terms of PA programs in the state of California, there are 13 accredited PA programs, with this no change from the last meeting. There are 2 pending programs that the ARCPA either has or will visit, and those programs should get an update in March from the ARCPA to find out if they become accredited, which would put us at 15. There are 3 additional programs that are in the application process with ARCPA. That process can go for a long time. So right now, in March, there will likely be 15 accredited programs in California, with 3 on the books for developing over the course of the next few years. I don't have an update to the sort of form that I made last meeting, because I don't have any information on those other programs about how many students they plan on taking or what their fees would be. But that's where the workforce education plan is going right now. In terms of the things we talked about, so items A and B last time, we spent a lot of time last meeting talking about having preceptors and sort of the rate limiting step for preceptors in PA education for students is the availability of preceptors, and looking at what Georgia and some other states have done to address that. One of the things we had talked about was maybe meeting with a legislator or conducting a study. So I sort of navigated around on the State of California website and found lots of workforce stuff on there. OSHPD has done a lot of workforce stuff. There's been some surveys done. And so sort of along the lines of what Dr. Bishop was talking about in our public protection mission, things like that. At this point, there's other people in the state doing those things. I think probably not something that our staff has availability to work on right now. Not sure that that falls within a major portion of our mission, although workforce is part of the issue. So my thought is that we should sort of let the other folks that are already working on that do that, and stick the public protection stuff that we're doing, but I would love to hear any input from other board members.
Just a quick question. The two pending, are those the two provisionally accredited programs that you mentioned, or is that? Did
Yeah,
you
the two
include those?
pending, there's one in the Bay Area and one in the Los Angeles
Okay,
area.
they're
And
provisionally
they
approved,
should
okay.
hear back in March,
Okay. Thank you.
or, well, maybe late March, early April, depending on when the ARC reports back.
Right. Okay.
First, I wanted to thank you, Jed, for the time and energy that you've put into this effort. I know you've spent a lot of creative and intellectual energy on this, and it's been a real service for us and I think for the field as well. I think that that what you're suggesting is the right course of action. And I also just generally think that this board is better set up to respond to legislation than to advance legislation. And so I suppose I would be hopeful that in your future conversations with those in the field and, advocacy groups and others who might be attempting to advance legislation, that you could mention the possibility of this board as being a partner in that way. And, certainly something we could review and take opinions on, what have you, but that's probably the better role for us.
Yeah, I think that that was my learning point
Yeah.
from all this, but
Yeah.
yeah, thank you. And if there's no other comments, that's it for our update for education and workforce.
Okay, so would everybody agree we're just gonna sort of put the education workforce to sleep for a while?
Yeah, I'm happy, if Dr. Alexander's happy to do it, to continue to, or, the committee should continue to report on what's happening with the PA programs
Okay.
in the state, so we know kind of what's sort of supply we're looking at over the next few years and what's happening. But just as an informative thing, I don't think there's anything else, unless there's something else the board wants us to do.
Okay, that's super. We'll keep you on the agenda.
Yeah, I'm good with that, too.
Okay,
Thanks.
excellent. Okay, we will go to item number 18. Development since February 2015, United States Supreme Court decision in North Carolina State Board of Dental Examiners versus Federal Trade Commission.
This will be a super brief update. There is no update. There was legislation last year, SB 1192, I think it was, and it died. So there is no change. And we'll continue to keep an eye on it. And if there's anything to report, then I will definitely let you know.
Thank you. Discussion? Public comment? Okay. We will go to item 19, the Medical Board of California activities. Dr. Bishop.
Okie dokie. The Medical Board held its quarterly meeting on October 27 and 28 in San Diego. The meeting's focus was on the board's Sunset Review report, and therefore no committees met due to the review of this extensive report. The board went through each section of the report and provided input and edits. One of the most important sections of the report was a section on new issues. The board is recommending changes in this section where legislation is needed to provide efficiency to the board's process. Some of the new issues included: 1, changing the number of years required for postgraduate training to require 3 years for all applicants, one of my favorites. Requiring reporting by accredited outpatient surgery settings, changing the notice required under Business and Professions Code Section 138 to include a requirement that the notice include information on filing complaints and checking a physician's profile. 3, establishing a limited education permit for individuals who are re-entering the practice of medicine after a leave of absence, which is a great idea. Requesting penalties for facilities that do not report as required in Business and Professions Code 80501, another great action. Enforcement and licensing process changes needed. And finally, number 6, asking for members from the board to be reinstituted to the Health Professions Education Committee. And for some inexplicable reason, they took our board members off that foundation committee, which we've been there for years, so we're hoping to come back onto that. A complete list of the new issues can be found in the board's report. The board voted to approve the report with minor edits. The report was submitted to the legislature by the deadline of December 1st, 2016. The board will be going through the sunset review hearing process in either February or March. The board reviewed all of its committees and task forces as required by the board's strategic plan and approved the committees and task forces as they are currently established. The board heard an update on its outreach campaign entitled Check Up on Your Doctor's License. The board has completed its tutorial, including a Spanish version of the tutorial, and has placed it on the board's website. The board has also translated its outreach brochure into Spanish too. The board is continuing to reach out to individuals, informing them of the board and encouraging them to check their doctor's profile on the board's website. The board held 2 regulatory hearings, one on changes to the board's citation and fine program to add additional sections of law, and to also allow the board to issue citations and fines to licensed midwives and polysomnographic technicians and trainees. The second hearing was on the requirements for physicians on probations. The board heard a presentation from Dr. Bolat on the University of California, Los Angeles' International Medical Graduate Pilot Program. She pointed out that developing new residency programs in underserved areas was a long-term strategy, knowing that many of those trained in an area would remain in that area, both for subspecialty and primary care. The board approved seeking legislation to extend this pilot program. The board reviewed the implementation plan for all legislation impacting the board, including the bill that authorized the board to establish a physician health and wellness program. At the meeting, the board approved staff moving forward with implementing such a program. The board has begun this process and held an interested parties meeting on January 11th to discuss regulations pertaining to this program. Board staff will now be drafting the regulations to implement the program and will hold another interested parties meeting prior to taking the language to the board. The board also held an expert reviewer training on November 5th, 2016 in Los Angeles. Those individuals that attended the meeting found it to be very educational and helped them to understand their role and function as an expert reviewer. The board also completed a brochure on the expert reviewer program that will be able to be used to hand out at events and presentations to assist the board in finding more expert reviewers. The board continues to be appreciative of the relationship it has with the Physician Assistant Board. The board offers any assistance it can to provide to the Physician Assistant Board with any future issues. The Medical Board will be meeting next on January 26th through 27th in Sacramento. And I have to give kudos to Kim Kirchmeyer, who essentially provided me with this report. Thank you.
Did she let you use it?
Yes, she did.
No, on the condition that you give her credit?
No, she's not that way, but she certainly deserves it. Anyone who knows her knows who she is. She's wonderful.
Any questions on Dr. Bishop's report?
Just,
Public comment?
I just had a quick question. 80501, can you just tell me what that is? I didn't know offhand.
I believe that is, if you'll help me, that's reporting by facilities when a physician has been disciplined or
Yes.
otherwise.
Okay. All right, thank
I
you.
believe that's what it is.
It is. If you're talking about 805 reports, yes.
Yeah.
Okay,
Yeah.
thank you.
Is that, okay.
Because
Is that
that's
okay.
very important for our disciplinary activities. If we don't know from the ground up what's going on, it can be a real problem.
Okay, moving on to item 21, Legislative Committee.
Great. So we're at the earliest stages of the 2-year legislative cycle, so there's very little for us to review at this point. I believe DCA identified 3 bills for us to take a look at. Few other bills have yet been introduced, and none of the bills has been analyzed. So we did not put together, our committee did not put together our usual bill analysis spreadsheet because there's just really not enough context without any analysis of these bills to flesh out a spreadsheet like that. So next meeting will be the big legislative meeting, and that's one where I would suggest we carve out a good chunk of time for discussing legislation. I did want to just briefly go through these 3 bills that are here outlined today. The first, AB 44, would make it easier for first responders of acts of terrorism to have their treatment claims and their disability covered by workers' comp. And it would be retroactive to those responding to the San Bernardino attacks. This could potentially apply to PAs, but it's not particularly relevant to the board's business. So we can continue to monitor this one. SB 34 at this point is really just a spot bill to look at drug treatment facilities, but we don't know what it's going to do. SB 43 might be of more interest to the board, and I wanted to pose a few questions to you here about this. The idea behind this bill appears to be that they want to give the state and researchers more information about antimicrobial resistance. So the bill would require practitioners to include on certificates of death information about antimicrobial resistance if such an infection were a factor in the death or known to be a factor in the death. It would also require acute care facilities and clinical laboratories to submit reports each year with an antibiogram of their facilities. So this raised a couple of questions for me. One, if PAs are expected to include information about antimicrobial resistance as a factor of death, is their current training and sufficient to allow them to provide this information?
Well, currently we cannot sign death certificates, so we don't get to even fill them out.
All right, great, no problem. So then I'm going to say this bill is not germane to this committee, and we'll watch it to see if it becomes germane, if there's anything inserted around PAs, but otherwise we may not have this one on the list. And that's about it.
Okay. Board members have questions? Public comment? All right, so the next item, item B, Catherine was shocked to discover at our October meeting that she was not off the board, that she is now in her gray shirt.
Shocked and dismayed.
So, as a result, she will hopefully be here for the entire year, but moving towards when she is no longer here, I have taken the action of asking Sonia if she would step down from the Legislative Committee and allow Mary Valencia to go on the Legislative Committee, and they both have consented to that proposal. So the new committee will be Catherine as chair and Mary as her other member.
Hopeful to return in the event Miss Catherine leaves us to the Legislative Committee.
So any questions on that? I thank you, Sonia, for your service, and once Mary takes over, we'll get you back on it again. Questions? Public?
I just want everybody to know it's been a pleasure working with Catherine. She's very knowledgeable about what she does, and it's just been a great opportunity for me to learn from her and be a part of the team.
I agree entirely. Back to you, and do hope that that you have the opportunity to bring all of your good wisdom back to the committee when we get all settled.
Okay, we're going to item 22, possible future presentation by the NCCPA. They contacted Lynn, I guess it was in November, offering to come out, and they disguised it as they wanted to come out and talk to us about workforce issues in California. I discussed this with the Vice President, Chet Grant. He was knowledgeable enough to point out that we have OSHPD that can give us all of the workforce information in California, which probably the NCCPA has access to. I think the full reason that they wanted to come out and make a presentation was to lobby for recertification, which is a huge issue for them right now because they're really under the gun.
What was that again? Lobby for?
Recertification.
Oh.
Since California does not require recertification, I'm not sure, my bias is not inviting them, but I wanted to put it on the agenda and have the rest of the board members talk about it. So it's open for discussion.
Well, is there anything you want to tell them? That would be another reason. That would be another reason to have them out. That you would have a direct access in a public forum, and if there's anything that you feel is important to discuss with them in that forum, that might be a reason to do it.
That's true, but I really don't want to give them the validation. Catherine?
Just a thought that, I mean, they've come up twice on two different issues. One where we're thinking about advancing legislation, and another thinking about changing a regulation that relates to them. I mean, it does make me, I feel like I don't know anything about them. So it would be helpful to me, at least, to learn a bit more about them as we're thinking about, you know, bestowing them with, I mean, really more responsibility, or at least codifying that in some way. So I would appreciate it.
Okay. Xavier, any comments?
I kind of agree with Bob, just
Okay.
not have them out.
Mary?
I'm okay either way.
Charles?
I'm good.
Sonia?
I think I would like to have them come and speak to us just to hear what they have to say. I don't think that's going to change our minds on anything, but I would be interested just to hear and at least know them face to face and know that we can speak to them and let them know directly what our thoughts are.
Okay. Javier?
I'm agree. I'm interested
Okay.
to hear a little bit more.
Jennifer?
Either way.
Jed?
Same, I'd be fine either way. I don't have a big burning desire to hear from them, but if the other members do, then I'm totally fine with that.
Part of it is going to be it's interesting that they have made this offer now, because in years past, we have requested that they come out, and we've always received a negative response. Now that they're on the hot seat, they can't wait to get out here. So,
But then also, didn't they have a new change of guard? Wasn't that it as well?
yeah,
They have a
but
change.
she's been around now for about 3 years, 4 years.
Another option is to, if they want to come and speak for, under the agenda item, the public comment for items not on the agenda, if they have something they want to say, I mean, the board's not going to be able to discuss it. But they can come and give their public comment, and depending on what they say, if you want to hear more and you want to have that conversation, you can invite them back or put them on a future agenda item. But, I mean, I'm just making a suggestion
Okay.
as an alternative, I guess.
Coming all the way from Virginia, so I suspect they're not going to want to turn around and come back again.
To be able to ask questions.
I mean, I'm willing to do what the majority of the board. Can I just take a vote without a motion? Or do we need a motion?
Well, I mean, I say always do a motion because basically one person says I want to do this, it's not hard for a second person to say, yeah, let's take a vote on this.
Okay.
So,
I think in our letter of invitation, I would like to include that the board may have some very difficult questions for them to answer so that they are prepared when they get here to answer those questions.
I agree, and I would add to that, I think it would be great if we could have the agenda item as open as possible so that we can ask about a wide range of issues, like the two we identified today, past issues / grievances, and really be able to have a full discussion.
Okay.
yeah, I mean, as long as it gets filtered down to Lynn, who puts it on the agenda, and then I look at it, I mean, it's possible that maybe Lynn can send it to everybody on the board to make sure that all of the topics are covered so that the agenda is broad enough.
Do they all have to be listed, or can it be
No,
more
it
open?
doesn't, but I
Okay.
mean, in terms of the general topic,
Uh-huh.
do you feel like reading it's sufficient? Because, you know, I don't want to, but I will. If you guys go outside of the scope of the agenda items, then I'll have to request some reading in.
I feel less inclined to list specific issues because I feel like I don't know enough about them. Right, and then it could limit the discussion.
So that's why it's helpful just to see how it's worded, to see if it's broad enough.
Yeah.
Yeah, so I'm not saying, you know, we want A, B, C, D, and E, but it can be a combination of those things. But, you know, we won't know until we see the agenda, and then we can kind of play with it.
Okay. All right, so I will entertain a motion to have NCCPA come out and give a presentation to the board members.
All right, second.
I can't make
Oh,
it.
I thought you,
Okay. Discussion? Public comment? And there's no public. Our call the vote, Dr. Alexander.
Aye.
Jennifer Colquist.
Aye.
Sonia Early.
Aye.
Javier Escobar Acosta.
Aye.
Jed Grant. Catherine Hazelton.
Aye.
Xavier Martinez.
Aye.
Robert Sachs. Aye. Mary Valencia.
Aye.
Okay, so we will send an invite
For the next
And-
meeting?
for the next meeting with some thoughts that we want on the agenda. Obviously, talking about replacing them is not going to be something they're going to be fond of discussing at all. But- Okay, so other items for the agenda? Obviously, workforce, budget. Regulations, medical board report,
CME audit, is that what?
CME audit, yes.
Oh, and Christy gave me something that she wanted me to, hang on, it's in my many pages.
How about the PA reviewer?
Oh, yes, PA review of cases.
Okay,
Complaints.
Oh, yeah.
Complaints, right?
You directed us to do.
okay, and this is, does she want us to review with the pharmacy board?
No, it was, I guess, something that the board had asked for, and, what?
You just rung a bell on the director
Oh,
of.
self-query report, sorry.
Oh, self-query, okay. The director of the pharmacy board has also volunteered to do a presentation at our next meeting regarding cures and any other questions you may have. So it's.
Okay. We can put that on the agenda too.
Is there any way we can talk about Breeze? And I know that they came about mid-year last year to talk about what phases that they were in and how we could implement or ask for things to be included. Is there a way that we can put that on the agenda to?
Do you have any idea if we're gonna have any hearings or
We
anything?
should.
More than one?
Hopefully, yes.
We're gonna have
Okay,
a
so
reg
we don't
hearing.
wanna load it up too much.
Okay, and Anita just said we're gonna have a reg hearing as well.
A
Okay,
reg hearing on,
but we might have to hold off on,
Yeah, you can just keep
on
like
five
a running
forty-six.
list.
yeah, okay. All right, any other items for the agenda? So we've skipped over one last thing that we need to go to, which is closed session pursuant to section 11126C, paragraph 3 of the California Code. The board will now move into closed session to deliberate and take action on disciplinary matters. At the conclusion of closed section, we will go back into session and